very warm welcome to you all. My name's Tabitha Cave and I lead our regulatory compliance team. We very much hope that you've had a good summer and a decent break too. We planned this session to help schools to prepare for inset and the academic year ahead, and we're delighted to have received such a positive response to it. Our aim is to inform or remind you of recent legal or regulatory changes and to identify changes to school policy and practice that we would recommend as a consequence. We'll also let you know what we expect from the new Labour government over the next few months in education law and policy. This session is for schools of all types, and as we run through the changes, we will explain the differential impact on schools of different types as appropriate. And in that context, I'm absolutely delighted to welcome Miriam Carrion Benitez to you all. Miriam is an eminent education law barrister who will be known to many of you and will be joining VWV as a partner on the 2nd of September to head the education law aspects of our academies and maintain school practice, given Yvonne Spencer's forthcoming and richly deserved retirement. We're also joined today by Victoria Guest, now a senior associate with us, who tracks education law and policy change, manages our compliance toolkit service, and maintains our own education policy suite. Between us, we will cover changes in the regulatory frameworks and key guidance, recent case law, and Labour's policy pledges. We'll finish with our summary of recommended actions before we move on to Q&A. As you'll know, we've allowed an hour and a half for this, but we've got a lot to get through. And with that in mind, I can confirm that the slides and the recording will be made available afterwards. So without further ado, Tamar, could you please move us on to the first slide? I always think it's important when you're talking about legal and regulatory change, not only to know what has changed, but to know what hasn't, so that you're talking from a firm foundation. So with that in mind, this is just a reminder that we haven't had any changes to the Education Act or to the Independent School Standards, no recent changes to the NMS for boarding either. But over the last year or so, well, if I say from 2024, we have had various updates, including updates to the early years foundation stage, changes to the legal duties on schools regarding registration and attendance, and as is usual in the summer months, updates to keeping children safe in education, following working together changes and changes to the Prevent guidance last year. And if we move on, then the early years foundation stage, the changes to the EYFS followed a consultation in 2023, which was part of the Smarter Regulation Programme. And there was also a consultation. And essentially, it was the government's response to concerns by EYFS providers that there were real challenges in recruiting and retaining staff. So what we have in the new framework, which has been in force since January of this year, are some new requirements, but not particularly stringent, but some new flexibilities and some clarification too. So just by way of a reminder, the EYFS refers to all schools providing education and care to young children from 0 to 5. And the new requirements are about ratios and about the qualifications of setting managers and qualifications for level 2 and level 3 staff. And in the first place, it's a requirement that setting managers must hold a level 2 maths qualification or achieve one within 2 years of starting position. And all level 2 and 3 staff members who've qualified since June 2016 must hold a valid paediatric first aid certificate. There is a minor tweak to the requirement for safeguarding policies and procedures, which is that in addition to explaining how each setting is going to use mobile phones and cameras, they also need to cover that for any electronic device with imaging and sharing capabilities. And on to the next slide. The guidance has been refined also to talk about flexibilities. So there are some flexibilities about ratios for those at level 3 who don't have level 2 maths, and there are some flexibilities in relation to counting students or apprentices in supervision ratios if the manager is satisfied that they are competent and responsible. One of the issues that providers reported was that it can be really difficult to comply with the requirement that there was previously to provide opportunities for children to develop home language and learning, particularly if it was in a multilingual and multicultural client base. And the requirement has been relaxed so that settings may now provide those opportunities rather than that being mandatory. And just for the sake of completeness, there are some other updates within the guidance, all intended to achieve the same aim. So a separate statutory document on early year qualifications, a relaxation of the need that if you're making an assessment of a child's learning and development, that you can do that with reference to the knowledge of the child and your professional judgment. You no longer need to keep physical evidence alongside it. Similarly, there isn't a need to keep physical copies of employee qualifications anymore, although you do need to make sure that you're satisfied that they have the qualifications claimed. And we had a little bit of a lack of clarity in the old guidance around paediatric first aid certificates, and the government has addressed that by setting out very prescriptive requirements about what counts or not, and that's set out in Annex A. So if we move on to the next slide is about working together, and you'll all be aware, I'm sure, that we had a significant update to working together at the end of last year. And that's guidance which, of course, relates to multi-party working and the significance of working together was that it hadn't been updated since 2018. In a large extent, the changes that have been made don't directly impact schools. A lot of the changes are about the way in which the local authorities perform their functions. But the revisions do give us quite a lot of useful insight into expectations about how we safeguard and protect children. So there's a real focus on providing high quality and effective support, and indeed timely support too. There's a real focus on holistic support to the whole family, and a real expectation now that wherever possible, children will be supported and looked after within a family and wider community environment wherever possible. Education, and in particular schools, are seen as a protective factor. And we know that that's behind all of the changes that we're seeing in relation to the new attendance guidance. But what has come out of that real focus is an expectation that schools must have regard to working together in the guidance, and that they must, as part of that, ensure that they are cooperating with multi-agency working. Schools are seen to have this important role in building relationships, identifying concerns, and providing direct support to children quickly. So that much has been overtly stated in Working Together. And alongside that, we also have an expectation that schools are going to really engage with local authorities, and that local authorities are going to facilitate that cooperation and engagement and consultation with education providers, where schools will use local authority audit functions, that schools will access local authority training for staff and governors, and that schools will share data with local authorities, all of which are seen as positive partnership working. Now, in terms of specific changes that you need to know about in relation to your policy suite and in relation to your practice, we've got some new definitions. We've got this new reference to kinship care arrangements, which is that broader definition of family. So it's not just parents and carers, but it's broader family, neighbours and the community, and how they can all be asked to engage and support children. This clarity of expectation that I spoke about, and indeed an extension of early help indicators. And we've got definitions to share with you about that. So Tamar, on to the next slide. The first and most fundamental is about a change in definition of safeguarding and promoting the welfare of children. So the aspects in bold on this slide are the changes. So we have a new first step that safeguarding and promoting the welfare of children includes providing help and support to meet the needs of children as soon as problems emerge. And it's that expectation that that's going to be timely, and it's going to be provided at whatever level is appropriate for a child. It fits and chimes very much with what we've seen over time about expectations about risk assessing pupil welfare. That came in the independent school standards previously, but this real expectation that you not only record what you know about a child, but that you then seek to apply what you know to assess their needs so that targeted support can be provided. We've then got some clarification about the duty to protect children from maltreatment. And that is clarification that applies whether it's within or outside the home, or online. And we're quite often asked by schools, you know, surely our duty is restricted to what's going on in school. We can't be responsible for everything that's happening outside. But there's that real reinforcement of a school's duty to be part of the holistic arrangement to protect a child, and that extends to what may be happening to them outside of the school environment. And if we move on and talk about the new practice principles, I thought this was quite useful to talk about. Essentially, they are practice principles for everybody who works with parents and carers, and they are designed to encourage collaborative partnership working between all services and parents and carers. And it's just a reminder about the need to work positively with parents and carers, not to be overtly critical, to work with empathy and respect, to help to manage expectations where you can. So the practice principles are around building strong relationships, using respectful language, empowering people to participate in decision making, even if they ignore you or actually are overtly hostile. It's looking and exploring at different routes. And it's involving the broader kinship arrangements around processes to affect families and to support them. And on the next slide, we've got a new definition of early help. This is providing support to children of all ages that improves a family's resilience and outcomes or reduces a chance of a problem getting worse. So this real focus on holistic support for the family. And what we had then was some new early help indicators relating to children who had a parent or carer in custody, a child who's missing education or persistently absent from school or otherwise not in receipt of full-time education, or has experienced multiple suspensions and is at risk of or has been permanently excluded. And it's important that we bear that in mind when we move on to talk about keeping children safe in education. So keeping children safe, which is the next slide, Tamar, was published in draft in May. I know you'll all know it was marked for information only. And Victoria's been in touch with the DFE and said, when are we going to expect the final version? And they said, any day now. And yes, of course, ahead of the new term. We were sort of expecting it to land this morning as we were preparing for this webinar. Essentially, what the DFE has said is this really is a year of light touch changes to ensure consistency. They say they're going to reflect the updated working together definitions and early help indicators that we've spoken about, although perhaps unusually this time, they've not used directly the same language. And then they've also made some change in emphasis to reflect what we've heard in dialogue over the last year or so. So more reference to exploitation, especially in the content on abuse and neglect, more focus on the impact on children of domestic abuse, even if they are not directly involved in it. So when they see, hear, or experience its effects. They have recognised that the frame, the term deliberately missing education indicates a degree of defiance and may be inappropriate. So talked of reframing that language as unexplainable and or persistent absences from education. And then there is a new heading and content relating to gender questioning children, which is on the slide, which is said to reflect the draft guidance and which Miriam will pick up in more detail. So if we keep going with the KCSIE changes, then there are changes in relation to the section on preventing radicalisation. We've got the new definition. And we've got the link to the prevent duty guidance. What we don't yet know is whether the new definition of exploitation will be inserted too. Then confirmation that schools remain responsible for the safeguarding of pupils they place with an alternative provision provider. We can't just say that that's now in the hands of another provider. We retain responsibility. And there are recommendations around using the DFE's data protection guidance for schools, using some age-appropriate guides to support children who are witnesses in criminal cases, and a reminder of the ongoing focus on record keeping. So if we move on to the next slide, there are just some words of caution, the things that we don't yet know. I suspect that many of you will have made those changes already to your safeguarding policies and procedures. But the bits we're still waiting to hear from the DfE are about the wording of early help indicators. We know the additional categories of children, but the wording is not currently wholly aligned in the way we've come to expect. And the content in relation to gender questioning children is still under review, as is that on preventing radicalisation and extremism. And what we don't know when the government talk about making technical changes this time round is whether they will make the changes that they had proposed or not. And we are expecting clarification, as I say, any day or any hour, and we'll let you know when we receive that. And just a reminder that they have already consulted on more significant change to keeping children safe next year, and we will expect a much more rigorous need for change next time round, and hopefully a lot more notice, but we say that every time. So I'm going to hand over now to Miriam, who's going to help us with the changes to school attendance.
Good morning, everyone. So with regards to school attendance, we've had recently coming into effect the School Attendance Pupil Registration England Regulations 2024. They replaced the 2006 regulations, and alongside the new regulations, the DfE has published a revised version of its attendance guidance, which came into effect on the 19th of August 2024, and reflects the regulations. The guidance is a statutory guidance and therefore applies to all types of educational settings, including independent schools, unless otherwise stated within the guidance or the regulations where there is conflict with the guidance. Now, you may all be wondering, do I have to review all of my processes and policies, etc.? I think the answer is not all of them. All the good work that you have done towards improving attendance at school is not wasted. The amendments in the new statutory guidance are fairly self-contained and, in my view, easy to manage in terms of implementation, but there will be a need for education of all school staff and community around attendance and the new aims of the guidance and towards improving attendance. Now, in terms of independent schools and whether the guidance applies to independent schools, the DfE has created a fact sheet for each type of school, which is very helpful. It's published just below the main guidance. As I've said, it applies to all the schools unless otherwise specified within the guidance itself. Independent schools can expect the same amount of support from the local authority. So the responsibilities of local authorities vis-a-vis independent schools have been clarified in the guidance, although there is some flexibility on how the local authorities will provide support in the context of attendance to independent schools. Penalty notices cannot be used by independent schools, as you know, but attendance prosecution can be taken and will be taken by local authorities on behalf of independent schools. Another difference between the academies and maintained sector and the independent schools is the that of attendance contracts versus attendance support plans. So independent schools will not have to have attendance contracts, but they can have an attendance support plan. This is because Section 19 of the Anti-Social Behaviour Act does not apply to the independent school sector. And I will explain why those attendance support plans and attendance contracts are so important in the context of attendance. And then the final main difference between the two sectors is that the 2006 regulations did not allow local authorities to access the registers of independent schools. However, under Regulation 12 of the 2024 regulations, local authorities now have a right to access that data. in respect of any school in their area, regardless of the type of a school. And the Secretary of State is also added to the list of persons who can examine the registers and take extracts, including from independent schools. So in terms of the role of the local authority, and I'm not yet following precisely the slide, I'm just giving you a brief overview, but in terms of the role of the local authority, what can the schools expect? And that's all the schools is reflected in Chapter 4 of the guidance. So the local authorities will have to provide a named contact in the school attendance team for each of the schools at the start of the school term in September. They will also have to hold regular targeting support meetings, and the DFE says that the local authorities and schools are to be seen as equal partners to agree actions to support attendance, rather than the local authorities dictating on the schools what attendance action should be taken, if any. They also need to offer schools opportunities to share good practice that was happening before, and agree a joint approach. There is much talk in the new guidance about a joint approach between local authorities and the schools in respect of severe absences of pupils and how to take forward any attendance intervention. Now, with regards to the key changes, the overarching emphasis of the new guidance is to move away from punitive measures, from sanctions, and to increase the holistic whole family support for families struggling with attendance. And this support will be underpinned, the guidance tells us, by schools having very good ongoing communication with families and schools understanding the barriers to attendance for that pupil. And this links up to links with the concept in the Keeping Children Safe in Education amendment that Tabitha has talked about, deleting the term deliberately missing education. It ties in with this. So the idea that we're not blaming children for missing education or families. We're trying to really support them and look at those barriers and see how we can improve that holistically at school, building those positive relationships with families to support attendance. The aim of the guidance as well is to increase that clarity between attendance and the wider school culture and the school ethos. And that's why the guidance is now asking schools to have a written school attendance policy. All the schools are expected to have this based on the expectations set out in the guidance, and you can find further detail, paragraph 26. Another key change is the designation by schools of a senior attendance champion, who will be a member of the senior leadership team and will have overall responsibility for championing and improving attendance in schools and liaising with pupils, parents, and external agencies. The next change is keeping maintained electronic admissions and attendance registers using national attendance and absence codes. And this now has to be retained for 6 years as opposed to 6 years. There is a huge emphasis, and I'm sure you're all aware as school administrators and educators, on the importance of data, and not just of keeping that data, but analyzing that data half-termly in accordance with guidance, and then annually for early identification of barriers to attendance. The idea is that schools with good data can put in place that early help to avoid absence to become entrenched. There is a new requirement on the AMS sectors and academies and NMSS sector to provide information about every student to the Secretary of State on request, and this will be done through an automated system. There is an updated section on physical, mental ill health and attendance, and this is quite important because it has, in my view, provided some clarity around those Section 19 issues and when it is that schools can expect the local authority to fully step in when a child has ill health for whatever reason and cannot attend school for 15 days or more, whether consecutively or cumulatively. Then with regards to the attendance contracts, these apply to the AMS sectors and the parents. The term has been changed from parenting contract to attendance contract to really provide clarity on what the expectations are around that contract. The contract is not legally binding, but it offers a more formal route to secure engagement with the support that is available. And it can also be used as evidence if the local authority later decides to prosecute that has been part of the escalation ladder towards a more formal sanction in respect of non-attendance. And the same would be the case for the attendance support plans in independent schools. The local authority and or the governing body should fund any support that is provided to improve attendance. And that will be a question of, for example, for parents to attend a parenting class on attendance, etc. And that will be a question of having that conversation with your local authority. Now, another change which ties in with the first aim, and that is the provision of holistic support to families who are struggling with attendance, is the graduated approach to escalation of sanctions or punitive measures. The guidance is clear that supportive approaches are the most effective way of eliminating barriers, and therefore there is a support first approach within the guidance that should be implemented by schools. There are some discrete changes to the attendance codes, and this follow from the Attendance Pupil Registration England Regulations 2024, paragraph 34 on chapter 8. While many of the new codes align with the previous coding system, there is more detail in the guidance to help the schools determine which codes to use, and training will be required for your school staff coming into the new year as soon as the year starts. Hopefully before then. There is clarification around codes used in relation to children with health needs, and these have changed slightly. They have become clearer. And the DFE have also confirmed, thanks to Victoria asking the right questions, that a pupil's absence due to non-payment of fees should be recorded as Y7, and the reason provided in the accompanying field of the form. And schools should not record these absences under disciplinary codes or record the reason for deletion from the register as an exclusion. Next slide, Taima, please. Just to bring into focus three aspects of the new guidance: the senior attendance champion role. I'm sure you all have those roles in place. Your senior attendance champion will have key responsibility for communication around attendance and sits at the center of the guidance to ensure that a joined up and coordinated approach is undertaken both with the schools, the local authority, and also with external agencies. I think that this is a good addition to the attendance system, given the increased complexity to attendance and continued challenges and changes to the law around attendance. So you will have one senior person that really can keep up with the changes and cascade those down. It does not mean that your champion is the only person responsible for attendance at school. Everyone will have to understand the importance of attendance and all the processes around it. The champion will have four main duties. The first one will be to set a clear vision and a strategy for improving and maintaining attendance. The second one will be establishing day-to-day systems and making sure everybody knows what's expected in the sphere of attendance. The third is having a strong grasp of the attendance data, and that will involve monitoring and checking back on all the processes based on that data to ensure effectiveness of your attendance strategies. And the data analysis requirements are quite clear in the guidance at paragraph 45. The second thing that I wanted to bring to focus is the effective attendance policy. The guidance does specify what content should be included in your attendance policies. That's paragraph 26. And one of the most important changes is that of provision first, escalation then, and punitive sanctions only if all the other avenues of support have been exhausted. With regards to the changes to the guidance in relation to pupils with mental or physical ill health, the guidance asks all settings to be particularly mindful of pupils absent because of those reasons, and moves away from the blame culture in the cases of ill health and also of pupils with special educational needs. The section has been updated to reflect the changes in other guidance that is related. So, for example, the education for children with health needs who cannot attend schools and providing a remote education and mental health issues affecting a pupil's attendance guidance for schools. I have included the link there for everyone to see. One bit of guidance that emanates from the NHS and is obviously not statutory, but is that is a document title is My Child Too Ill for School. It's quite helpful to share that document with families, and it provides a bit of a yardstick as to when a child might be too ill to attend school. Finally, on the point of ill health, there is reviewed guidance on part-time timetables and reduced timetables, and further clarity on that issue and the role of medical evidence in respect of part-time timetables. There is an additional sickness return. You will find everything that you need to know about the sickness return. Is the only return that is new to the regulations. You will need to include a full name and address of the child, of a child that is termed as absent under Code I for illness, where the child has been absent for 15 days consecutively or cumulatively. And there is an additional duty, which is the schools must now make sure that if they know already that a pupil will miss 15 days or more, they have to send the sickness return in advance. They don't wait until the child has been absent for those 15 days. That is new in this guidance. So moving on then to wrap up attendance for the AMS sector in particular. We've looked at those mandatory data collection requirements that can be met by giving the Secretary of State through your MIS systems access to the electronic data. The DFE or the Secretary of State is not going to analyze that data unless they need to do so for whatever reason. So you cannot, unfortunately, expect much assistance in the analysis from them. Then there is a new national framework that applies to the AMS sector for issuing penalty notices that has come into force and reflects the changes in the law. The DFE believe that it is now a more effective deterrent. It has moved from to 80 pounds as a penalty notice, or 160 if it's not paid, and there's a limit of two penalty notices in a 3-year period before moving to prosecution. The national threshold, just to say that the national threshold must be considered, but it's not a trigger to issue, but only to consider issuing. And you would look at whether in the 10 sessions of 5 school days, there has been an authorized absence in the span of those 10 school weeks. Finally, yes, we have there the duty to consider issuing penalty notices, but it's not it is not a blanket approach that you must issue a penalty notice when there is issues with attendance. Just a couple of points on holidays during term time. They have articulated what a holiday means within the guidance, and you could refer to that in your own attendance policies. And the penalty notice system will operate on a clean slate from the 2024 academic year, so you will not count attendance from the previous year towards those sessions over the 10 weeks. Moving on to the next slide. We're looking now at mobile phone use in schools. So this is a piece of non-statutory guidance that aims to help schools develop policies, and within that, the a school should consider reviewing any existing policies on mobile phone use in light of this non-statutory guidance. The DfE proposes different approaches for different year groups and cohorts, and a range of sanctions for breaches of the policy, and where relevant adaptations, reasonable adjustments can be made for individual pupils, for example, those who use the phone as part of their medical care, etc. All of that needs to be considered before any sanctions are imposed. The guidance gives 4 examples as to different approaches: no phones, phones handed in on arrival, kept in a secure location, never used, seen or heard, etc. And it also does unequivocally state that boarding schools and residential schools should prohibit the use of mobile phones throughout the teaching day. It emphasizes the role of parents as partners in enforcing mobile use policies within the school. It ties in with 3 other sets of important pieces of guidance: the search and screening and confiscation, creating a mobile-free environment, and the toolkit for schools. Just with regards to the toolkit for schools, always a word of warning of how that's used in respect of children or pupils who require adaptations or reasonable adjustments by reason of their SEN, disability, or protected characteristic. So that is me back to Tabitha, I think.
Indeed, thanks, Miriam. So I'm going to move on and talk a little about security. We had some updated guidance on security. First of all, the main security in schools guidance was updated in July, and we had some new protective security and preparedness guidance in April. Both mirror each other and build on what we're always expected to do in health and safety terms, in terms of assessing and managing risk and reducing the consequences of that risk materializing. But it is ever more in schools consciousness and the national one following the catastrophic events in Southport at the end of July. So I thought it would be useful just to take you through what is set out in the non-statutory guidance on protective security, but which I think is really useful for schools, and I would commend the guidance to you and all of the additional resources that are available free of charge. So the guidance that is on the slide is accessible and separate from the main guidance. We have some checklists that can be used by schools in terms of planning and in terms of reviewing the arrangements. If, for example, your governing body want to undertake an appropriate review. And there is also some e-learning resource which is available free of charge. The idea in all of this is that it is about promoting a good security culture, and as I say, minimizing the chance of terrorism or other serious incidents and the impact if they are to happen. And there's some really accessible suggestions within the guidance. So, for example, the see, check and notify approach is pretty accessible. It uses the wonderful term of hostile reconnaissance, but essentially it is about being observant, being questioning and curious. It's about checking if you notice something, and the guidance refers to the power of hello and the fact that even just a very innocuous challenge, if you feel safe to do so, can be enough to deter inappropriate action and to detect someone. And then the notify is obviously the reporting in, the notifying others if you have concerns. There is talk, which I hadn't seen publicised before, of the new anti-terrorism hotline within the guidance, which I will circulate otherwise, but is 0800 789 321, and that supplements the Action Counter-Terrorism online form, and of course the opportunity to contact the police. So that's about noticing suspicious activity. There then was some additional support about noticing suspicious items and use of the HOT acronym. So is the object that is questionably suspicious, is it hidden? Is it obviously suspicious? And is it typical? So if, for example, you see some wires in an electrical toolkit, but you know there's an electrician working down the hall, you may be slightly less worried about it than if it seems completely atypical or unexpected. And a protocol then about how you would report that in. It also talks about the value of considering case studies in your school and considering how people should respond. There is specific guidance on how to respond to a gun or knife attack, and that's the run to a place of safety. And if you can't run to a place of safety, that you hide insofar as you can, and then tell others when it is safe for you to do so. Good guidance that can be shared with everybody. And then consideration of the 3 response options that an organiser may have to deal with live incidents, in terms of locking down the site, locking people in order to control a situation, or indeed evacuating people depending on the circumstances. If we move to the next slide, there is a recommendation of a new appointment. And this is the recommendation of an appointment of a security lead. It is only a recommendation at this stage, but I think it is good practice, and it's good practice to sit alongside, but not necessarily to be the same person as that person who is responsible for health and safety within your organisation. And the idea in relation to your security lead is that they will develop and maintain policies and plans for you, that they will promote a good security culture, and they will be responsible for disseminating information and for ensuring that people have the right training, that people are consulted in relation to security arrangements. And it is then optional for them to lead the management of live incidents if they are tasked with that as part of their role as a security lead. One of the cohorts that are particularly drawn to your attention in the security guidance is those people with special educational needs and disability. And of course, you will need to make sure that all of your plans and arrangements are inclusive and accessible. And there is a suggestion that as part of your general risk assessments for them, or separately, that you will have personal emergency evacuation plans where appropriate. And just a reminder that it might be useful to have grab kits of key items that can assist during an incident, whether linked to particular individuals or to groups of individuals within that matter. So if we move on, the Conservative government prepared the Terrorism Protection of Premises Bill. This is the one that we've been speaking to you about for a while, also known as Martin's Law, driven by the response of Martin Hetz mother who lost her son in the Manchester Arena bombing. And essentially, this is a bill which Labour have said that they will adopt and will adopt quickly. We don't know when, but we've done a whole webinar on this, which I can share. And essentially, it requires those responsible for certain premises and events to take steps to reduce the risk of a terrorist attack and to mitigate the impact should one happen. Now, schools, it's not specific to schools in terms of the proposed law, but schools will be caught by it. And there are different degrees of rigor and requirement depending on public access to either a school building or event. So events can be outside, depending on whether it's public access of more than 100 or more than 800, depends what is required. But the take home that I would give in relation to this aspect is we do have security guidance. We know it is a live issue. It's within our consciousness. We have a duty to take reasonable steps to protect those we're responsible for from terrorism. And we've now got some really useful guidance and frameworks to enable us to do so. Back to you, Miriam. Thank you.
Thank you. Thank you, Tabitha. So we come to the topic of gender questioning children in schools. We had hoped to have clear guidance on what schools were expected to do in this arena, but the guidance remains now a draft guidance, and as a result of the new government may be amended, and in some areas, I don't know whether a new consultation would be carried out. The weight that you attach to the guidance is entirely up to you. It does provide some clarification, for example, in respect of the single-sex schools and what they are to do, but in respect of anything else, your main guiding document continues to be the technical guidance for schools and, of course, the Equality Act, which applies to all types of settings. We had the CAS review, the final report, come out in April 2024. And although it does not include a specific recommendations for schools, it does ask schools to adopt a cautious and a neutral approach and advises the schools against proactively initiating action towards a child's social transition. So that's a position of watchful waiting. And that's the advice currently given to schools and the approach generally adopted by schools. And this is because social transitioning cannot be considered as a neutral act, is something that has to be viewed as an active intervention, and it may have significant effects on the child or young person in terms of their psychological functioning. So schools must be very cautious not to be an active agent in that social transitioning. So where are we now? The duties under the Equality Act continue to apply for all types of school, and for the academies maintained sector, you have the additional duties under the Human Rights Act. The technical guidance for school was updated in September 2023. It has been recently updated as well, but in relation to gender was updated in September 2023 and provided some further examples and clarification around how schools should behave and in relation to gender questioning children and how to support these children. We still have all of the duties that flow from the Keeping Children Safe in Education and Working Together guidance. That is that the welfare of all children must be paramount, and no child should be treated any less favorably than others. in the access of effective services which meet their needs. In practice, there may be, I think, more guidance in the technical schools documents than anywhere else for schools, and that's the document that you should really refer to every time that you are facing an issue or a query around gender questioning children. Schools do have and continue to have a specific legal duties framed by the child's biological sex, and the children's legal sex is always the same as their biological sex. None of that has changed. There is no general duty to allow a child to socially transition, and indeed no legal duty to do so. And there is no requirement to have in place a standalone policy on the management of gender questioning pupils. The Sutcliffe case is a very interesting case. It came out recently, I think it was in July 2024. It reinforces the need for ongoing staff training. I'm going to pause just a little bit on this case because it might be of interest to the audience. So in the Sutcliffe case, the High Court upheld the ban on a teacher who had deliberately misgendered a transgender pupil in the classroom and had outed him on national television. It's a very well-known case. It's a very, very extreme set of facts in this case. And following a 6-day hearing, a professional conduct panel found him guilty of unacceptable professional conduct. And the Secretary of State then accepted the panel's recommendation. The teacher brought an appeal on the grounds that he had a right to freedom of religion and belief, and that right had been breached by the school, in essence, asking him to respect the child's wishes for those pronouns to be used. The High Court found that the objectives of treating children with dignity and respect and of safeguarding their well-being were sufficiently important to justify the limitations imposed by the school. The court in this case was assessing the actual teacher standards rather than whether the teacher's own views were reasonable or not. Within the judgment, there is reference to a very good analysis on the Quality Act in this area, and also reference to the Keeping Children Safe in Education. The judge said, and I'm reading verbatim, a teacher's right to believe that no one can self-identify as a different gender and that homosexuality is a sin against God, as this teacher believed, is protected by law, but does not entitle the teacher to fail to treat transgender, gay and lesbian pupils with anything short of the dignity and respect with which all school children must be treated, or justify a failure to safeguard the best interests and well-being of such children. And then the judge said, just because misgendering a transgender pupil might not be unlawful does not mean that it is appropriate conduct for a teacher. And at the end of the judgment, the judge notes that all educators should keep in mind the Keeping Children Safe in Education guidance, that all professionals must have a child-centered approach at all times that works in the best interest of the child. And therefore, any justification for the interferences based on a teacher's own beliefs on religious grounds or broader beliefs grounds can be hard and will be hard to justify after this case, particularly with regards to the well-being of the children. In this case, the head teacher had been very good, has sent a letter to the teacher in question stating or asking the teacher to speak with him if he found that his own beliefs came into conflict with the school ethos. And the court praised that approach. Next slide, please. So just a reminder of the definition of gender assignment under the Equality Act, which I have included there for all to read in your own time. I'm conscious of the time that we do have. So in law, a transsexual person is a person who has the protected characteristic of gender reassignment, and that includes but having undertaken a medical procedure, but not only, or having taken steps to live in the opposite gender, or proposing to do so. So it's a very, very wide protective characteristic. In another case on transgender rights, the judge in that case observed that only a proportion of people who identify as transgender will have such a protected characteristic. So it tried to narrow the definition under Section 7. So in relation to any requests from a gender questioning child or young person, it is very important to consider whether the pupil may fall under the definition of the Equality Act, because if they do, distinct duties, anti-discrimination duties are triggered for all schools. The Equality and Human Rights Commission, in their technical guidance, one of the updates that they did was precisely on the use of pronouns and examples on when schools needed to respect gender segregation in school, etc., and updated definitions of sex and gender reassignment. Please, next slide. So when considering whether you accept a request to socially transition at the school, it's important that you do not adopt blanket approaches. You have to consider each case on a case-by-case basis, look at whether they fall within the definition of gender reassignment, and if so, how you can ensure compliance under the Equality Act. You will also allow for watchful waiting, which is what the CAS review recommended schools, that they adopt a neutral role and you take your time. There is no need and no legal requirement to comply with requests to socially transition in, but there is a legal requirement that you consider that request insofar as that's imposed, that sort of preemptive requirement is imposed by the Equality Act. You will be encouraging as the school's medical advice and considering any other mental health or well-being implications and whether additional support is required whilst you are considering that request to socially transition. You will take into account the views of the parents in the draft guidance. If a gender question in relation to gender questioning children, the government then said the parents' views continue to be at the heart of all of the decisions made by the children. We don't know whether this is going to change or not. We also have the other side of the coin is that, and that's what I've called here, the dwindling right, that whilst parents should not be excluded from decisions taken by a school, there could be a legal argument that if the child is sufficiently intelligent or understanding, they can make a decision without parental consent. This point has not yet been litigated, and there is no case law on this point. You will also look at the age of the child, the seriousness and the context of the request, the long and short-term impact on the child, the impact on other pupils, and the impact on the staff and the wider school community. Moving on then to the next slide. In relation to gender questioning children, schools will continue to ensure that competitive sport is fair and safe for all pupils, looking at those sport exceptions under Section 195 of the Equality Act, and the considerations on what stage of development the child has reached and whether making differences will cause discrimination or not, etc. You will have sex-separated toilet facilities for pupils aged 8 and above, and changing accommodation and showers for pupils 11 and above. You will continue, this has not changed, to protect single-sex spaces with regards to toilet showers and changing rooms, etc. In the technical guidance on toilets and changing rooms, it does say, as a bit of a warning, that schools that fail to provide changing facilities for a transsexual pupil and that insist on that pupil using a particular sex's changing rooms or toilets could amount to indirect discrimination, and suitable alternatives ought to be considered. and reasonable adjustments made as well. The school uniform guidance has to comply with the Equality Act, and the school uniform guidance provides some helpful pointers as to what schools should be doing. So schools should consider a request of flexibility to a uniform guidance and how that people could be accommodated. But they are not expected, schools are not expected to develop a new uniform policy as a result. So you can consider that on an ad hoc basis, depending on each individual request. And then the use of pronouns, you will read the case of Sutcliffe, no doubt, or you probably have read it, and should be considered individually, and a refusal, blank refusal to use alternate pronouns is unlikely to be unjustified or proportionate. A final note on the gender questioning section is that single-sex schools can continue to refuse to admit pupils of the opposite biological sex, regardless of whether they are questioning their gender or transitioning. However, a school cannot, a single-sex school cannot refuse to admit a child of the same biological sex on the basis that they're questioning their gender. And if the pupil is already on roll at a single-sex school and questioning their gender, then it will be a question of having that conversation with the families as to how to make those accommodations, if possible, for that pupil's new gender, and whether it is the best option having regard to the well-being of the child. So now a few three cases that I wanted to touch on very briefly. Taima, next slide, please. So the Michaela Community School Structure Judgment, BWB did a very extensive seminar on this. I'm not going to repeat what we said there. I represented the local authority of Brent in that case, who were the first interested party. The sole reason why I want to emphasize it here is because since the judgment was published, I've had multiple clients ask me for advice as to whether changes to their policies, in particular their uniform policies, could be made in line of this judgment, because some schools have interpreted it as giving almost carte blanche to restrict freedom to manifest one's religion without justification. So just a word of warning that justification still needs to be there. The new measures need to be proportionate, and it's important to understand what your policies have been today, what change you want to introduce, and what impact this will have on a particular group with a protected characteristic. The Michaela Community Schools Trust judgment was very, very factor specific in a school with a very specific ethos. So it's a particular pupil, a particular school, in a particular place, a particular time type of case, and therefore I would warn against using that as a yardstick to change policies where it will impact on a pupil with a protected characteristic without proper consideration. The next case is a case that might be useful to both the AMS and the independent sector, and that's TS and SM and Liverpool City Council. It is a case where basically, in essence, the Upper Tribunal says that whenever a local authority wants to make a decision on placement, whether it is to place a child at a school or to stop a placement, for example, at an independent school on the grounds of inefficient use of resources, they must take into account the views, wishes, and feelings of the child. They can't do it in a vacuum. So it will be important in those cases, whether it is for AMS or independent schools, that if you disagree with the local authority's position on placement or ending placement, that you ask them for the child's views on how these have been obtained. And if they haven't, the decision is likely amenable to challenge. The last case is the Coram Children Legal Centre case, which is pending judgment, but this is just to put a pin on this. There is currently a pending judgment to the lack of legal aid funding in relation to independent review panels and permanent exclusions. The judgment is expected in October 2024, and I think it is likely that they will succeed. The current government has said that they would appeal if the case succeeded. That means that so a success in this case would mean that children who have been permanently excluded would have access to legal aid, thereby, I think, quite naturally increasing the number of cases that will be taken to an independent review panel and ultimately to judicial review. So that's me done, Victoria. Thank you.
Hello, I'm going to speak a little bit about what we're expecting from the Labour government in the coming months. We've set out on the next 3 slides, and I won't speak about them in great deal, about the Labour education pledges. As many of you will know, during the state opening of Parliament on the 17th of July, the King set out the government's priorities for the coming months, which included some commitments relating to education, including children's social care, schools and further education. Their focus is on breaking down barriers to opportunity and raising standards. And they've announced 2 bills, one of which is going to be quite important to schools, and that is going to be the Children's Wellbeing Bill. We're expecting this to be introduced in 2025, and it's going to introduce a range of changes, including free breakfast clubs in every primary school, limiting numbers of branded uniform items schools can require, requirements for the local authorities to have and maintain not in school registers for children and provide support to home educated parents. For academies and maintained schools, they're going to modernise the school curriculum. We've just had the curriculum review announced, and the intention is that all state-funded schools will have to teach in a national curriculum. They'll bring maths into the inspection system. Those are the main changes. If we could go on a couple of slides to the one about what is and has been dropped, what we're expecting, what's off the table. As you'll be aware, the previous government committed to introducing mandatory reporting as an amendment to the Criminal Justice Bill. Now that we have a new government, that commitment hasn't been repeated yet. However, there has been a bill, the Regulated and Other Activities Mandatory Reporting of Child Sexual Abuse Bill, has been introduced as a private member's bill in the House of Lords shortly before the summer break. So this will mandate providing and carrying out regulated or other activities with responsibility for the care of children to report known and suspected child abuse. It will protect mandated reporters from detriment, and it will create a criminal offence for failing to report. Then the gender questioning children guidance. So the Labour manifesto at the present it included a pledge to work to implement expert recommendations of the Cass Review and to ensure children and young people presenting to the NHS with gender dysphoria have and receive appropriate care. The RSHE guidance, a consultation was launched shortly before the general election and closed shortly afterwards. We haven't received any intel on whether that will be published or whether that will form part of the curriculum review, but the expectation is that it will be. So if we now hand back to Tabitha to talk about some of the recommended actions.
Thanks very much, Victoria. So yes, what we're going to do now is just sum up our recommendations in the light of all of those changes. Every year we say, oh, it's going to be a quiet summer period, we're going to get a summer break, and every year we seem to be right up against it, waiting for clarifications from the government, and this is no different. So you'll need to think about your policies and procedures. You'll need to update them. So if you've not done so already, you need to review and amend your policies and procedures. Chief amongst those is the safeguarding suite. And as I say, it is likely that there may be further tweaks, even if you've done it already, that will be required this week to address some aspects in the guidance which were marked subject to confirmation. I think all schools should be reviewing what they already have by way of security and these security arrangements. Some schools will deal with those as part of their health and safety policy suite. Some will have a standalone one. Either is acceptable. And then you'll also need to think about changes to document retention policies in light of Miriam's comments earlier about the requirement to keep attendance data for 6 years. Schools haven't had to have a standalone attendance policy previously. Many have had, and we have developed a template policy which schools can contact us to access. So that's one to add to the arsenal and to make sure is covering both the new regulations and the guidance that's been talked about here, and is specific to the type of school that you are working with. Do think about whether you need a standalone mobile phone policy. It can be covered in your acceptable use policies. It can be cross-referenced in codes of conduct, but increasingly we're seeing schools have standalone policies on that. And do think, as the government has, about other devices that are not mobile phones but which facilitate online access. That might be smartwatches, it might be tablets, can be other things. And also think about whether you now want to have a separate gender questioning children policy. Again, no requirement to have one, but some are choosing to. Miriam mentioned about the requirement for a senior attendance champion in a school, so I'm sure that will be on your radar, and the roles and responsibilities that are expected are set out in the guidance. But you may also want to give thought to whether you have a designated security lead and a designated mental health lead, given the increased renewed focus on both aspects and increasing amounts of guidance suggesting that those are in place. As we think about inset, which I know will have been planned already, but there is some nuancing I anticipate that can still be done, you also need to think about training. And that will be training of your staff and training of your proprietor body, especially in safeguarding attendance and security. And I've noticed that there are some questions about, well, what does that training need to cover? And essentially, what is always covered in the guidance is sufficient training to enable people to understand their role and what they need to do. So there's no set standards. There can be minimum repetitions and refreshers, but you absolutely need to make sure that the training that you are providing is suitable and sufficient for the roles that people are doing. And do please bear in mind that in safeguarding terms, that should include training in the local arrangements that you have, not just the national guidance. And on to the next slide, Tamar, please. I think it is absolutely essential that the annual reviews of safeguarding, which will be overseen and conducted by your proprietorial body, should now include attendance, given all that we've heard about non-attendance being a major safeguarding issue, and given the amount of change and scrutiny that's being applied to schools about the arrangements to promote attendance of children. But you may separately want to think about whether, as part of a governing body role or something that is organised separately, to think about reviews of the school's local engagement with local authority and local safeguarding partners, the security arrangements, checking that your EYFS arrangements are appropriate and that you are mindful of the changes to the regime. You may want to think about the arrangements and support you have for your gender questioning children, and you may also want to focus on the suitability of any alternative provider provision you've arranged for pupils, particularly in relation to safeguarding and promoting their well-being. And all of that for independent schools is alongside the planning, which I know is in hand for the introduction of VAT on fees from January. And we've just done a mailing on that, which I'm happy to share for anyone who's missed it. And we'll also be covering it at our Independent Schools Practical Strategies Conference at the end of September. And again, can send details of that to anybody if helpful. So those are our summary of actions. I think we have a few minutes for questions. So I will hand back to Victoria, who has kindly agreed to coordinate those for us.
There's a couple of questions relating to Martin's Law and the Terrorism Protection of Premises Bill about whether public access will include general public and whether open mornings would count. At the moment, the draft bill was published under the previous government. We haven't seen the current bill, but the expectation is that any sort of providers, charities, and schools that run events will be caught by it. But the original intentions and the procedures that they're expecting to be put into place are going to be reasonable based on what is happening in that context. So smaller premises in the standard tier will probably be expected to notify the regulator of the premises to put in place reasonably practical procedural measures to keep everybody safe. Could be as simple as educating staff on locking doors and evacuation procedures. They're trying to make it as simple as low cost as possible. As Tabitha mentioned earlier, we have done some webinars on this. I'm sure that we'll be able to provide links when we send out the slides in due course. So thank you.
Thanks, Victoria. Are there any other questions?
I'm just looking now. So other questions there's some that I think are being answered by Miriam with regard to the attendance guidance, which in particular, which sections apply to independent schools. Maybe Miriam, can I refer back to you?
Yes, apologies. I think there has been some confusion, likely caused by me. So what the DfE have published is a summary table of responsibilities for school attendance. It's not exactly divided, or is not divided by school settings, type of schools. But what this means is that the summary table of responsibilities, if it is listed there, you have to do it, whether you are an independent school or a maintained school. Because the summary table includes the duties for all the schools and not just for the academies and maintained sector. Does that clarify? In terms of the things that do not apply within the guidance to the independent sector, the penalty notices, which cannot be used by independent schools. So there is no fines being imposed by independent schools. They can still access prosecution, but that's done by the local authority, not by the schools. The local authorities will be taking action on behalf of parents, on behalf of independent schools. And another thing is that the local authority previously did not have a right to access the registers of independent schools in relation to attendance. Now they do. And just one final point of clarification is that the Secretary of State does not have this access in relation to independent schools, only in relation to the maintained sector and academies, that access to the attendance registers by the Secretary of State. So those are, I guess, the main differences to highlight. Victoria, do you think that answers the question?
Yes, thank you, Miriam. I think some of the other questions that we have answered, Tabitha in particular, relating to governor training and proprietor training and staff training. And we'll be circulating those slides after. I'm not quite sure exactly when we're going to circulate them, but they should be before the beginning of term.
Wonderful.
I have just seen
very much.
Tabitha, sorry, I've just seen at the very end somebody saying, talking about VAT, and I understand that you have a seminar planned in the near future. Is that right?
Yes. Absolutely. We've got we've got a full day's conference, which is practical strategies for independent schools. And we did a mailing where we're pulling together all of the various themes about VAT on schools, which I can share if someone hasn't received it already. Thank you, Miriam. I think that brings matters to an end. Tamar has very kindly launched a feedback poll for us in relation to today's session. I can confirm that we will be sharing both the slides and the recording, and we will deal with any other unanswered questions if we can. So thank you all for joining us, and I hope you have a very successful preparation, inset and start of term.